Common Pleas Judge Thomas Harris ruled Friday the defense team for accused murderer Marque Daquan Brown can't use actions by an emergency room doctor and staff at Ashtabula County Medical Center as a contributing factor in the death of Brown's 17-year-old pregnant girlfriend. Prosecutors sought a decision prior to the June 10th capital murder trial of Brown. The 22-year-old Brown is accused of beating Tasha Ramirez about the head after she accused him of infidelity. Her family pulled Brown off Ramirez in the bathroom and called for an ambulance and also called police. This was back in May of 2014. Brown was arrested. Ramirez was checked out at Ashtabula County Medical Center, then returned home where she was found to be bleeding profusely. She was rushed back to the hospital where she and the child died. Brown's defense team, Richard Denolfo and Dean F. DePauloff, stated a report commissioned by the defense and conducted by Dr. John R. Becker showed gross negligence by the hospital. But Harris could find no such language in Becker's report. Handling the prosecution are Assistant Prosecutors Brett Hardup and Margaret A. Draper.
Your Honor, in our brief, we are asking the court to allow the testimony of our expert, Dr. Becker, based on his supplemental report from April 7th of 2015, where we believe intervening cause can be proved by showing that there was gross negligence on the part of the hospital and the doctor involved, emergency room doctor involved. We would ask the court to take into consideration and to that maybe ruling on this motion at this time is premature. All the information that the defense is submitting stating that there was gross negligence or an intervening cause of willful and wanton recklessness on the part of the hospital is based on not any depositions of witnesses, doctors, or nurses, but it's based on the discovery we requested from the state of Ohio and the information that was provided to us. Your Honor, the defense believes that we should have an opportunity to cross-examine those state's witnesses and possibly call witnesses from the medical field of our own before the court would rule on the merits of this issue at this time. But we believe there is intervening causes, that there is willful and wanton recklessness, and that's indicated in Dr. Becker's supplemental report. The fact that, in this case, the victim, Taisha Ramirez, did go to the hospital. She was a minor at the time. She had family with her. Her mother had to sign for her. Her mother doesn't speak English. From the reports received by the prosecution in discovery, and from the nurse's reports of contact with her, she was only there for an hour, and they basically shoot her out the door. I think we would be able to prove by the court hearing the fact that there was gross negligence on the part of the hospital, Your Honor, and that that testimony should be allowed and should be put in front of the jury to show that there was intervening causes, that her life and the life of the baby could have been spared, that the hospital had acted differently. So we ask you to take that into consideration. Take into consideration, I know that the state cites a number of cases, the State versus Champlin case that was actually tried right here in this courtroom. The facts in this case, which are not fully before this court, can be distinguished from all the cases that the state has cited in their brief, Your Honor. Thank you.
And Mr. Topalov, there are two reports or letters from Dr. Becker. The first is dated May 25th, 2014. That was prepared for your defense team, for your client. In reading that report, I see absolutely no mention of any opinion of Dr. Becker of gross negligence of any medical staff. And I'm referring to the term gross negligence. Is that correct?
Your Honor, I think he does not use the term gross negligence, but basically, in summary of that report, he's saying the emergency room actions and actions of the doctor and nurses was not a competent evaluation. And part of our argument is we're differentiating from cases that the state cited where if a person had, they make the argument, more skillful medical treatment or a better higher quality hospital. We're not arguing that. We're arguing that if she would have just gotten competent health care, we wouldn't be here today, Your Honor. And that's because the hospital was reckless and willful and wanton in the disregard to the patient and the victim here.
But Dr. Becker doesn't say that. He doesn't say there was gross medical negligence. He doesn't say any of the terms that you're using. And in fact, on the second page of his May 25th, 2014, the second paragraph, he expresses, in his professional opinion, his conclusion as to what the cause of death is, and that's pretty absolute. That's not real favorable for your client.
That's understood, and that's why we were asking the court that we be allowed to present a defense of an intervening cause.
But your expert doesn't use the term that the reviewing courts require. And then looking at the April 7th, 2015, he again, Dr. Becker, does not use the term gross negligence. And I mean, there can be some speculation as to what could have happened if something else had happened, but it does not override Dr. Becker's opinion in the second paragraph of his first letter as to what the cause of death is for both Ms. Ramirez and her fetus. And that's the standards that the Supreme Court and the Court of Appeals require us to follow. And I believe it states simple negligence is insufficient to prove the causal connection. The standard is gross negligence and willful maltreatment, which there is absolutely nothing mentioned by Dr. Becker in either one of his two reports.
Talking about what nurses reported, what the patient reported to the medical staff, and that's why I think it's premature for the court to make a ruling at this time until we've had a chance to cross-examine or to prove, and I think it should be a jury issue, whether the hospital acted willfully and wantonly and recklessly in the treatment of the patient.
But your own expert doesn't say that that ever once occurred. He has, in his two opinion letters, identified things that he thought could have been handled better or differently, but he does not use the clear, concise medical terms that the Supreme Court and the Court of Appeals requires to let that type of evidence in. I mean, it's pretty clear.
Well, just in response, I mean, our expert is not a lawyer. He's responding in, I think, medical terms rather than legal terms, and I think that's his testimony would be subject to interpretation, and we would interpret it and argue it to a jury that his findings, based on what is in the report and what we would, I think, we would hope to gain from cross-examine of the state's witnesses, would prove our point, Your Honor.
As the state has in its motion, Black's Law Dictionary defining what gross negligence, willful, wanton, reckless negligence means. And it is as follows. The usual meaning assigned to willful, wanton, or reckless according to taste as to the word used is that the actor has intentionally done an act of an unreasonable character in disregard of a risk known to him or so obvious that he must be taken to to have been aware of it, and so great as to make it highly probable that harm would follow. It is usually accompanied by consciousness and indifference to the consequences, amounting almost to willingness that they should follow, and it has been said that this is so indispensable. The report by Dr. Becker contains on April 7th, the second report that was provided, words such as in retrospect, probably, likely, in other words, I feel, that are used in that report. There's nothing in there, as the court's already identified, with the language that the report provided by Dr. Becker would show that anybody working in the ER would have done something different than what was actually done by Dr. Haniff. Furthermore, the discovery that was provided to the defense is the full medical records for this case. The police reports, all information that the state has been provided to the defense. There's nothing that has been withheld. So the doctor's, Becker's assessment and report on this case is based on what is in fact known, what occurred, when it occurred, and the report, as the court's already identified, does lack any type of response stating that gross negligence occurred in this case.
I feel that it's very clear that the court is required to grant the state of Ohio's motion in limine to preclude evidence or testimony of alleged medical negligence as an independent intervening cause. So the state of Ohio's motion will be granted. We will be issuing a written decision. Now, Mr. Topala, we had discussions in chambers with the court not issuing yet its written opinion, but announcing what my intentions are. Was there anything you wanted to move the court to do?
Thank you. Yes, Your Honor. I mean, at this time, we would ask the court to seal the record as it pertains to the report of our expert, Dr. Becker. I guess in light of your ruling and in light of this case proceeds to jury trial, the information in there would possibly be prejudicial. We think it would be highly prejudicial to a jury panel, especially if there's not to be allowed in open court as part of the trial. So we would be asking the court to seal the record as to the medical reports submitted by the defense for.
And that's both the May 25th, 2014 and April 7th, 2015 opinions submitted by Dr. Becker.
Yes, those are the only two submitted.
Any response from the state?
No objection, Your Honor.
Okay, that request will be granted without objection. Anything further on this matter on behalf of the state?
Nothing further, Your Honor. Thank you.
Anything further on this matter from the defense?
No, Your Honor.
Okay, thank you.
Thank you.
Thank you, Your Honor.
Sergeant, you can transport him back to the county. Thank you, Sergeant.